Global Freedom of Expression Project, where he analyzes judgments bordering on freedom of expression subjects covering over 120 jurisdictions across the world, including the United States, Europe, India, and Africa, among others. He is a 2016 Research Fellowship recipient of International Center for Not-for-Profit Law, Washington, D.C. He was specially recognized in 2017 Heroes of Human Rights by Access Now. Solomon was specially recognized as a finalist at the 2018 Global Freedom of Expression Prize, Columbia University. We also have Mr. Alan Ngoma as one of our mentors and resource persons for today's training. I'll go ahead to read his profile. Mr. Alan Ngoma is a versatile professional with extensive experience in both data science and software engineering, currently excelling as a data scientist at Zamara, Kenya. His role entails collaborating closely with clients to unlock the full potential of metadata, utilizing advanced data competencies to extract meaningful insights and streamline processes. Prior to his current engagement, he served as a machine learning engineer at the United States of Africa, where he specialized in developing and deploying machine learning applications tailored to project requirements. His professional journey has encompassed roles such as data scientist at Bitco Africa. Additionally, he served as a research economist at the National Treasury of Kenya, where he conducted in-depth research on economic factors, designed surveys, interpreted data, and forecasted market trends. Driven by passion for translating data into actionable insights, he is committed to empowering businesses to make informed decisions and achieve operational excellence. Each role has contributed to his growth and expertise, and he is eager to continue making significant contributions in the field of data science and software development. And we look forward to enjoying his wealth of experience, expertise, and knowledge in today's training session. We also have joining us today Ms. Kodichima Anigbogu. Ms. Kodichima is an astute legal professional with a wealth of experience in commercializing intellectual property and in data protection. She is involved in various facets of these areas of law, from advising clients and identification and exploitation of intellectual property rights to preparing documentations for IP transactions. She also conducts trainings on intellectual property and entertainment law. On the data protection front, she holds a CIPPE qualification from the International Association of Privacy Professionals. She advises on data protection laws and conducts data protection audits and trainings. Kodichi has authored several articles on intellectual property and data protection. She has authored several articles in intellectual property and data protection and is a contributor to the Thomson Reuters Digital Business Global Guide for Nigeria. Kodichi is a senior associate at the prestigious law firm of Jackson, Etty, and Edu. We also have as one of our mentors, Mr. Ridwan Batmus. Ridwan Batmus is a tech lawyer, multidisciplinary privacy professional, and CTO. His expertise extends across various specialized technology law domains, encompassing artificial intelligence, blockchain, cloud computing, and other cutting-edge technologies. Being a certified information privacy technologist with the IAPP and an esteemed OneTrust Fellow of Privacy Technology, Ridwan is at the forefront of translating privacy regulations into functional applications that handle users' data, a significant void he diligently fills. Furthermore, his unique position in working across numerous complex projects bridges the gap between legal and technical teams, thereby harmonizing two distinct domains in his expansive technological landscape. Ridwan's ardor for the effective implementation of privacy and security best practices is evident in his active involvement in shaping industry standards set forth by eminent organizations such as the National Institute of Standards and Technology, the Cloud Security Alliance, and the Center for Internet Security CIS. Finally, we have joining us on today's training, Abishola Oshin. Abishola is a seasoned corporate and technology lawyer with over 14 years of experience in legal and corporate practice. She has gained extensive expertise in corporate governance, privacy, regulatory compliance, capital market, OEM engagement, managed services, software services, intellectual property, and fintech. She's a visionary leader who has been instrumental in supporting transformational change for data protection at CWG PLC. As a group head of legal, she has played a pivotal role in the implementation. She has played a pivotal role in the implementation and enforcement of data protection regulations and policies across the group, while leveraging technology and innovation. Abisola has also provided, I beg your pardon, Abisola has also provided critical legal advice and guidance to management and the board of directors on matters relating to data security. Before joining CWG PLC, she served as the primary legal officer at EAN Aviation, a ground handling and fixed base operator in the aviation industry. Abishola also worked with Stream Sowers and AMP Con, a leading commercial firm in Nigeria, where she provided legal advisory services to both local and international companies. Abishola is a graduate of the University of Lagos, Igbenidian University, and the Nigerian Law School, where she obtained her bachelor's degree, LLB, and BL respectively. She also holds an LLM in International Trade and Commercial Law from Durham University. So that is a brief profile of each of our mentors today. By the way, this is week 3, and we shall be having our mentors take us on the topic data subject rights. Data subject rights. Can you all hear me? Can you still hear me?
Oh,
Hello,
yes,
everyone.
Yes, we can hear you.
All right. So we'll go ahead to take on the business for today. So I'd like to encourage the mentees to turn on their videos. You can turn on your videos and also effectively participate in today's session. We have question and answer segment at the end of presentations from the mentors and then the mentee groups. We're going to start with presentations from the mentors, which will be immediately followed by presentations by group mentees. Okay, so once these presentations are done, you would have an opportunity to ask questions and seek clarifications on concepts and ideas that you do not quite understand. So endeavor to make the session engaging and interactive. So we're going to proceed to the presentations now. I understand we have Ms. Kodichi on call already. So we're going to start with Ms. Kodichi. Good evening, Ms. Kodichi.
Hello, Nathaniel. I don't know, it might just be me. Your audio is a bit low. It was better earlier, but I've observed it's a bit low. But yes, I'm
Is
good
it
to
better
start.
now?
Yeah,
Is
yes,
it better?
it's fine. It's fine.
Okay.
Yeah.
So please, Ma, you're going to have 15 minutes for presentation.
Okay.
Thank you very much. The floor is
All
yours.
right. All right. Okay. I'll share my screen and then quickly start. Just confirm if you can see it. Anybody? It's not coming out very my end. Let me see. Hold on. Just give me a moment. Okay, we see it. Okay. Okay, let me try and I will just get right into it because of time. All right. Hello everyone. Good afternoon. Glad to be here again, and we'll just quickly get on it. Have a lot of mentors on the call, and I'm sure there's so much to say. So I won't go too in depth into it for the benefit of the other mentors, so it doesn't feel like we're all going to be saying speaking to the same thing. So I'll just try and quickly run through. So just a brief overview really of where these data subjects' rights are coming from. So it's trying to stem from the Nigerian Constitution, Section 37, that guarantees the right of privacy. So there's already a right to privacy along with right to life, right to movement, freedom of association, and all the other rights. But the Constitution also provides for that right to privacy. And what has happened now is that the Nigerian Data Protection Regulation, which came before in 2019, and then the Nigerian Data Protection Act has further, broadened and strengthened that privacy rights in the different forms, keeping in mind with what technology has done and, the importance of data today. So in the different forms that the right can be expressed and different forms that it can be utilized, these rights are now further guaranteed by the regulation and the acts. And this is very important because prior to the regulation, when people were having issues in relation to their privacy rights, they're still able to, go to the courts, based on the existing, constitutional and fundamental human rights. And even nowadays, even now in cases that are being, instituted in court, there is reliance also, or there is a combination of using the Constitution, the fundamental rights in the Constitution, and these other rights provided by the laws. So it really makes for a strong case when one's privacy right has been breached. And just to also show how active your rights as a data subject are, and that people are paying the price for abusing that privacy, so to speak. So there's a 2021 case between Omotola Quadri and Zenith Bank, and I know some of us, I don't know who has experienced that. We have these banks that we have our accounts, and they send us all the emails telling us every single thing that's happening, even if it's downtime, if it's marketing, just even if it's key emails on KYC. So she was receiving all these emails from Zenith Bank. Meanwhile, she didn't have an account with Zenith Bank. So that was very, interesting and problematic, because where is this information coming from? And an account being created in her name, what was, going on? So it turned out that someone else had opened an account with, I think, a similar name and surname, but had supplied the email address. At least that was the claim from the bank, right? And that was why they were reaching out to her. It was like a case of mistaken identity, or, correction or error in the data provided. So really, at the end of the day, the Ogun State High Court, ended up fining the judge in the court from the High Court, ended up fining them about 500,000 for, that, invasion of privacy and really spamming someone that's not your customer, right, with unnecessary or unsolicited emails. And something else that data protection, the Nigerian Data Protection Act, which I'm sure we all know is the, extant act for data protection in Nigeria, has also done, is also spoken to, marketing emails and, rights to, object to such marketing and also. While this happened, in accordance with or in line with, there was already that law in place. It just goes to speak to, that reliance also on maybe using the Constitution to speak to an invasion on privacy, or also the fact that even where she was a Zenith Bank, in the event that she was a customer of Zenith Bank, the point still remains that if she did not subscribe to marketing emails, they will not be able to send her that. So I'll just quickly touch on, the rights as you can see them on my screen. we'll look first at the right to be informed and the right to complain. Just give me a sec so I can ensure that my audio is not, there's some noise. Sorry about that. I'm back. Hope you can hear me. So yes, the right to be informed is the right as a data subject, as you and I really, because as we know, data subject speaks to individuals, personal data processing or personal data speaks to identifiable information. So the right to be informed is really, I think it's provided from the beginning of section 34 in the NDPA. And it's speaking to all the things you should know if your data is being handled or being dealt with. So it spells out a list of things that, organizations should do when dealing with your personal data. So, for example, you should know how your data is being collected. So someone like, let's use Facebook or let's use Twitter, Instagram, for instance. Even you're in school, number of you are in school. So even your universities and the likes, right? If they're collecting your information because you're a student and the likes, they should actually be informing you how they are collecting it, why they are collecting it. If they're not collecting it from you, if someone else is making it available to them, they're collecting your information from JAM, for instance, they should let you know that they're getting it from JAM. If they're going to share your information, really submitting it to like a general body, for instance, those of us that studied law, or are studying law, your information might be passed from your university to the law school and things like that. That's a transfer of information. If your information is going to be moved, if there is use of automated decision making in handling your information, how long your information is being stored, how you can complain if there's any issue with your information, all that is enshrined. They are required to provide you with all that information. So it's like there should be a one-stop shop. And they also say that you should be informed by anybody dealing with your data that you can complain, which is interesting. It's like, okay, I'm telling you how I'm using your information. I'm also telling you that if you don't like the way I'm doing it, or if I'm breaching your privacy rights in any way, you can actually take this matter to the NDPC. I was going to link it here, but yeah. So the Nigerian Data Protection Commission actually has, on their website, like a reporting link. So where that kind of thing, most organizations would also provide you with that link. Beyond, okay, complain to us if there's an issue, you can actually take the matter to the regulator as well. So of course, like I mentioned, these rights, there are so many, this right to be informed, there's so much information that you need to know because the law specifically states what you should be informed about. So of course, how are you going to be, how fast, what is the best way you can get this information across? If people are not filling forms or you're using one process or the other, you don't have that time in a physical, interaction one-on-one. Imagine me here, just like, this is how I'm going to do this is how I'm going to do that, and the likes. So what has happened is privacy policies and documents like that, privacy documents, serve to guarantee that right by providing you all the details. And that's why it's always important to, read the privacy policy for any sites, any place where you're providing or feeding in information, because that is where they are guaranteeing your right to privacy, your right to information, and telling you all you need to know. And we've had instances, I've had clients, where they had to have their privacy policy reviewed because data subjects reached out that, oh, you're not providing this information in your privacy policy. It's against my right. I should be aware of how you're handling this. And, we had to help them update the policy. So that's an important right to note. Quickly, the next one, right to rectification. So that's speaking really to being able to correct information you have provided. Your phone number could have changed, if you're, a customer and like, you're working with, for instance, even a bank, right? Usually they have like phone numbers, they have email. If your email address has changed, you should have a right to, have that corrected. Or people keep misspelling names. I mean, this is Nigeria, where heterogeneous, there's so many different names, and someone will put the wrong vowel somewhere, it completely changes a person's name, and that's going to be the end of that. And like the case with Zenith Bank, where just by changing one letter, emails can be going to the wrong person. It's as simple as that with the kind of names, unique names we have and the like. So you should be able to, have your name changed, updated, corrected if there's a mistake. And furthermore, the organization should provide you with a means to make that change. And that's something that they would state in their privacy policy. So it's almost like the rights are tying together in a sense. So Instagram will tell you, or Facebook would say, oh, even LinkedIn, I think, oh, is this still your phone number? Is this still your this? Is this still your that? So it's almost like prompts for updates to take in any correction, right? So it's apart from you having the right to go to them as a data subject, having the right to go and, request the change, organizations also have to be proactive to ensure that they have the updated information. For them, of course, there's a business case. It benefits them. The information they're trying to pass across is getting to the right person, but also it is a statutory and legal requirement because you could lose out on important information and details you need to know because of those kind of errors. So that's something that's a very important right. So right to be forgotten and erasure, this is speaking to like deletion. And to be frank, it's not in every circumstance that it can be applied there. Some of these rights do have limitations, just like, the general fundamental human rights do have their limitations depending on the instance. But, if we have a business deal, have a contract, I just want to buy this, supply this, and I'm done with you, you've supplied it, you had my home address to make the delivery, I can ask you to, delete it, we're done. There's no further interaction. That's a good right. If I'm closing a bank account, right? And that one I've actually noticed is kind of problematic in Nigeria. When you close your bank account, because I've done that with one of the banks and I'm still getting emails from them. I'm like, let me take this forward and see, see what money I can get for these people breaching my privacy right, because I'm no longer working with you. I no longer have my money in your bank. Why are you still sending me? I mean, why are we still communicating? That kind of thing. So you should be able to exercise that right to be forgotten, that right to deletion. But you could see the examples I have on the screen of the limitation. This is where it's no longer needed. So if for any reason it might appear that the data controller, a good reason, of course, because they would have to come out and defend their rationale behind it, of this is why we still hold on to the information. But if, for instance, I know that I have a money lending app or something, imagine me coming to request that my information be deleted. Meanwhile, I'm meant to pay back next month. Who is going to, respond to that and treat that? So these rights are not absolute, right? They're dependent on where things are. Yeah. So if I withdraw the processing consent, of course, I have a right to have my information deleted, right? And if there's also the very important one of if it was not lawfully gotten. So when you get some information and some email, like, how did you get my data? Delete my number, delete this, don't ever send to me again. That's exercising the right to be forgotten. And if you're actually still being reached out to after, there's definitely a claim that, can be made. And like we have it here, there is no other basis for retaining the data or to comply with the legal there's no reason to comply with the legal obligation. If there's a lawful basis, like I mentioned, the one where there's a contract in terms of me repaying a loan and I'm asking for a deletion, it's not going to be possible. Of course, that's limited. The right to restrict processing. So this can happen in some instances, and it's like not a partial forgetting, a partial erasure. It can be used in an instance where, let me maintain the example of the lending company. So fine, we still have the contract in place, we still have the business deal, but I don't want you marketing me, selling me your other loan, options and all that. I can actually say, do not send me marketing emails. So that's a restriction in how you process data, my data. Beyond processing it to provide me with the service, we're also processing it to, keep me updated, and tell me what's new, what loan product you've created. But I've said no, so I've restricted processing to that extent. And I can also restrict processing where there is an issue and you were relating with me, but we now want to check that the data is not correct. So there's now an issue, rather than deleting, because there are business cases, there are issues where organizations can actually say, this is why I have this information. I'm saying that someone has a note taker. This is a data protection class. It's very, 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 very wrong. There's a lot of issues regarding AI note takers because, I wasn't notified and it's going to be taking video recording, screenshots and things of my personal data, my voice. And, I have my name on the screen. and things like that. So that when we talk about data protection, these are the kind of things we're actually talking about, where all these rights, yes, need to be emphasized and insisted on, right? So restricting processing would happen where you're holding on to that information. You can't delete it yet, but you cannot reach out because we're trying to verify. What if I have a lawful basis for holding on to your data, but you're no longer interested in me processing it, right? What if my reason overrides yours? It's almost like looked at a government scenario or an NIN situation, or maybe during the COVID-19 time, there was holding on to information for, checking, contact tracing and things like that. But you're like, no, don't do that. There's an issue. I might decide not to, reach out to you. We might decide not to reach out or not to use your data for certain things, but I may not delete it because at the moment we're trying to resolve if the grounds for which I'm holding on to the data is legitimate, right? And it still works because purpose can change. Purpose can change at times. There's something to also bear in mind. So there's a right to withdraw consent. This is where consent was the basis to process. And that should kind of be borne in mind in some situations, because I feel like, your last training you had or last session was on lawful basis. So you know that there's more than one lawful basis, right? And in many instances, there can be more than, there can be two lawful bases simultaneously occurring. I can, consent to your use of my information, but also because of a contract, you are using my information. So if I want to withdraw that consent, but then there's still another basis going on, I might have withdrawn consent, but that contract is still, still makes it necessary for data to be processed. So that right may not be exercised to the extent that, the person would like. But then there's something else. The organization has to ensure that if I am providing consent, for instance, to receive marketing communication, if you no longer want to receive, that marketing communication, you should have that right as well to refuse. So you can't have a situation or scenario where I opt in and all I'm seeing is opt-in button, and then I want to unsubscribe. I'm sure we've even experienced that you want to unsubscribe from an email and then you are checking, like, I don't want to receive this information anymore. And the unsubscribe button is either it has disappeared or it's hidden or it's kept in a very obscure manner. That's what the the UI UX designers and the product designers tend to do. They try to make these things, the application designers, make things kind of a bit hard. So that it's like, oh, I just give up. It's too stressful going through the unsubscribe process. That's not what the law requires. It has to be, ensure the ease to separate yourself from that and withdraw your consent has to be ensured. So the right to object to automated decision-making. So automated decision-making relates to the use of technology in making decisions, and that the importance in that is that it should not affect the rights and freedoms of the person. There have been issues with, I remember a case, I think it was in the UK or so, there was an Uber case. And then I think the person's maybe facial recognition technology or something just made the decision that this wasn't the right driver or something. And I think it's because the person was Black. That kind of thing. So those are things where AI, their determinations or their decisions are being made, and it's just happening automatically. The algorithm is just making this decision based on this or that, and that can actually affect your rights and your freedom. So I have instances here, right? So if AI is reviewing a job application and is screening out applicants, what basis? That's an automated decision making based on what's the algorithm in place that is determining who does what, right? And there are actually parameters to the use of automated decision making, and that there should be some human oversight so that when there is an issue and it pops up, humans can then interact with the data. Why was this decision made? Is this correct? Is it in order and the like? So it shouldn't just be free for all that someone can use artificial intelligence or can have the technology and it just makes those kind of decisions that would be discriminatory, really, which is the focus, to avoid discrimination as a result. For instance, someone trying to take out, an insurance premium, to insure their car, and then the AI and everybody checks out and just determines that, hey, this person lives this kind of life, and then you make that decision as a result and things like that. And then it's like someone may be getting a different pricing as a result of another person, and it's just based on those kind of calculations and So things like that should be, you have a right to refuse that. You have a right to not be subject to that, which is how the law kind of puts it, right? Not to be subject to decisions by automation. And then there are some limitations. It's not every time that you can refuse it. If the contract process would be using AI, or the reason for we're entering into a contract for the provision of a service or a good, and AI just has to be involved and it's necessary, you can't really get out of that. And where the law will require it while protecting data subject rights and freedoms. So it's possible that there could be CCTV and it's just recording specific things and it's taking notes of specific individuals that come into the view of the camera and things like that. And it could be law enforcement or a camera that is doing a specific thing. It's like almost saying, oh, this person is overspeeding. I think in Lagos we have the speed cams or something, and like, oh, this decision, this, that, and all that. It's lawful in the sense that it's being put in place by what the traffic agencies, and is serving that purpose, But then you're looking at, is the right of the data subject being protected in what is being done? Is it person being discriminated against? And then, of course, if you have consented, to the processing being used, that automation is, being used to make decisions, and you've consented to that, object, that is a different thing. I think in that instance where if the processing of data was done by consent, the best thing you have as an option is to withdraw your consent and just end that relationship where possible. But those are limitations to that right to refuse it. Then speaking to data portability, which just really speaks to the movement of data. Yeah, so it's a very interesting right, because if I decide, like I told you now, I try to close one bank account, and let's say I decide to open accounts in Zenith, what this is telling me is I have a right. First of all, I can ask for all that data, everything I have provided to you to open this account, give it back to me. Then I can also request that my data goes from the old bank, send this to Zenith. So you can just imagine the drama that will be happening when, things like that really, really, really get. And it'll be nice to see if anybody, any of the other mentors who have had like live cases of actual data portability where the rights or the information actually moved, especially for competitors, because most of these organizations, you're going from one competitor to the next, everybody's trying to, do business and the likes. But the fact that you as an individual, you can collect the information an organization holds on you is very, very good. It's very key, but there's also a bit of a limitation. So in the regulation, the limitation is to be if the information was provided, in a machine readable format, or if it was imputed, right, you could get it out. But if there were other means through which the data was collected, you may not be able to get it out. And then there's also the aspect of the data controller being able to charge, because it costs some money to get the information, or it costs some money to transfer maybe handwritten information, and I have to send it by courier to the new competitor or the bank and all that. So I think that is kind of the small comforts that organizations would have if they have to send information to their competitors. They could use that to to soften the blow of losing the client in that instance, or to make some extra cash. But of course, I'm sure the fee should be reasonable, and if there's an issue on that, it's always good to, the regulator is there, the NDPC, so people can go back and then maybe they're haggling, this is how much they said they paid to do this, it's unfair, So what data protection has really helped, and having a strong regulator in place, having those laws in place, so you're able to then, as an individual, have rights over your information. Because at the end of the day, it's very important to recall that the information is yours. The data is yours, but organizations are using it. They don't own your information. And this is what data subject rights and guaranteeing this serves to, to remind. While it's not easy at times to push or fight for your rights, having that knowledge and understanding that it belongs to you. So anyone else that wants to deal with it has to toe the line is a good one to note. So of course, there's the right to object to processing. I gave the example on, direct marketing, and, if someone is sending you marketing, buy this product, Jumia is sending you mails and things that they're selling and all that, you have a right to object to. Don't use my email address to be sending me this. This is only what I need my email for. Or, don't use my email to, deal with me at all, to send any emails to me at all, or don't call me. Once you object to that, they have and they must implement that. I'm remembering a case, but it has to do with the right to be forgotten. I think someone had I don't know if it was like a criminal past or there had been an issue and it ended up being all over Google and the likes. And for years, anyone searching out would always see that story with the personal data of the individual. And I think at a point, the person finally sued, after trying to exercise the right to be forgotten, and they were fined for not implementing that at the end of the day. So it's something, a really big thing that organizations have to, bear in mind. Just quickly, the limitations here, where the data controller demonstrates a public interest or has a legitimate ground for utilizing that personal data and it overrides your rights and interests. So it is not taking away the rights, but it's more important that that information, be made available or something. And instances for public interest also have to do with health grounds. Because imagine the Ebola case, thinking back, if that information had been there and it's like, okay, anybody, if you see, there's some things where you would notify. If you see this person and you have to deal with that data, and it's like anybody who sees this person, avoid that person for your own safety, things like that. Okay, security reasons as well. That public interest or legitimate grounds gives a controller enough room to wiggle around. And I have to still do this. I still have to share this information. I still have to process this data because this would be, the consequence. And like I say here, it does not apply in a direct marketing situation. If it's purely marketing, it should be stopped. So penalties for non-compliance, where you breach privacy rights, is stated in the law. There's a criminal liability aspect for an organization. Its principal officers could be imprisoned. Organizations may have to pay hefty fines. There's a current one we're talking about with the Fidelity Bank in relation to breaching not just privacy rights, I think violating the laws, other laws, provisions of the act. And we're talking about 550 billion or so, there's a lot of money looking at, whichever one, the greater of 2%, annual gross revenue, how much money do banks make? And you're saying you're trying to take 1% or 2% of it, or 10 million naira, based on the classification the organization falls under. The other things also the regulator can do in terms of, ensuring you compensate a data subject. So it's like, okay, pay this person 1 million for what the person has been through or things like that. Or even where there's organizations are data mining. So they take that information and then they sell it and they're making money. So you might actually have to give accounts and return, bring out the money that you have made from carrying out this privacy, breach and things along that line. So court of competent jurisdiction, High Court, Federal High Court, we hear cases on data privacy breach. So in relation to protecting rights of data subject for, looking at international data flows and the likes, the scope of the law, the Nigerian Data Protection Law, covers data of residents. So if you are a resident in Nigeria, right, and your data is being used abroad, anywhere, organizations, it's a global village now, so anybody from anywhere can be, dealing with information. So they can be caught based on that, they can be caught under the law. I think, there's a FCCPC, Consumer Protection Council, has fined a Meta. Can't remember what year that happened or, what status it is at, but they had worked in collaboration with the Nigerian Data Protection commission regulator. So those kind of things where they need a show of might, it might not be one regulator working alone. There are many government agencies that can come together when there's a big, organization, or to sanction foreign organizations that may be dealing with personal data. Even the last case where the lending company was fined, so-called loans, because they were taking so their customers, they were having access to the phone numbers of customers, contacts of customers. So you just, you have a friend, and because you have that friend and you have that person's number is on your phone, they would call you and say your friend was owing and things like that, no lawful basis, no anything, and things like that. So I think they carried out investigations on lending companies like that. They worked with FCCPC, they worked with, I think, EFCC, a couple of different government agencies got together for that. So that's kind of actually what happens in those instances. If it's a very large organization, a foreign organization, and the NDPC may not work alone. And so I'll just stop there. Know that others still have a lot to say. Thank you.
Thank you very much, Ms. Kodichi, for such an enlightening session of training. Thank you very much.
Sorry, Mr. Nathaniel, are you still with us?
Hello. We're going to get back to you. At this juncture, we'll just go ahead.
Okay, sorry, I think Mr. Nathaniel is having a little network issue. So we'll be going over. Okay, Mr. Nathaniel, are you back with us?
Yes, I am.
Yes, all right, please, you can carry on.
Okay, so we're going to go on to the next presentation from our next mentor. Mr. Alan, are you on call? Mr. Alan Goma.
Hello, hi, can you hear me?
I can hear you. Welcome to the class.
Okay, thank you, thank you. Let me share my screen. How are you doing? Okay, please confirm if you can see my screen.
Not yet.
Right now, is it okay?
Yes. Yes, we can see it now.
Okay. I think, okay, my name is Alan. I bring a lot of greetings from Nairobi, Kenya. I think Kodichi has shared a lot of information. I'll try as much as possible not to regurgitate whatever she has said, and also try to highlight a few things that I feel they're also interesting when it comes to data subject rights. So we all understand that data subject rights are very critical and are very important, not only to from an organizational perspective, but also from a personal perspective, right? Also, you need to know how your data is being collected, is it being used, or is it shared to ensure like you have that clarity from a personal view, and also from an organizational view, you have that duty of care to your data subjects, right? And I think my colleague has also mentioned uh, most of these rights. That is the right to access, rectification, erasure, and also processing. So I'll just skim through each, try to highlight some of the things that I feel like are very important. And before I get into each, I felt it's important also to see some of the key principles when it comes to data subject access rights, because generally when it comes to the data protection, there are the general principles, that is the data minimization, storage, and the rest. But when it comes to data subject rights or access rights, there are key principles, that is like the transparency. When it comes to organizations, they need like to make it clear of how they collect their data, how they use their data, and who they share that data with, and why do they share that data with. And also, of course, that has to be to abide with a particular lawful basis, that is either consent, legal obligation, legitimate interest, and the rest. And also, there is the aspect of the user control, where persons have the right to access, correct, delete, and restrict. I mean, where now users, they have their own rights when it comes to their data which is collected. And in this case, I'm talking about like predominantly PII information, that is personal identifiable data or information. And also there is the aspect of accountability. Organization must demonstrate compliance with the data protection laws, and I think my colleague has also mentioned something like a privacy notice to showcase how you utilize these data, and also ensure like there's a form of communication to your data subjects who you do collect that data with. Okay, so when it comes to the right to access personal data, and I feel like, and most of them that have been explained, there are three key aspects. That is the request, access, receive response, and also review information. When it comes to request access, as a data subject, as much as you have this right, you need also to understand like from these key principle of transparency, an organization needs to give you a channel where you can request your data and receive a response as well. And I'll be mentioning some of the tools that organizations might use to ensure this is facilitated seamlessly, right? Then we have the right to rectification. You also need also to keep on upon access and reviewing your data. You need also to rectify inaccuracies. Let's say, for example, you feel your date of birth doesn't sit well because most of the organizations they tend to send happy birthday messages. Maybe you might receive an happy birthday message a day that then you're wondering who was born on this day, and then they're telling that's you. Then you're wondering is my data correct with this particular organization? Then you can go ahead and rectify that data. Right, then there is provide proof, where a person should provide evidence to support their request for rectification. Because, for example, maybe an organization would request you your national identification card. Then now it's the organization's responsibility to ensure they must update that data because when it comes to the general principles, there is the principle of accuracy where you need to keep accurate data from your data subjects. So it's their responsibility to ensure that data is being updated as needed. And also, of course, there's the verification process to ensure this is the person who is trying to rectify this data, because this is very critical when it comes to verification. Because I mean, I was working in that particular organization. It's an insurance company, and a guy who was paying premiums for a medical cover, he had a side child who his wife didn't know, and now at some point the wife came to request the statements for this particular guy, and the lady realized there's another kid who she doesn't know, but has been added to the cover, right? You see, and this lady, this guy rushed to the court to claim that there's an infringement on her right, and indeed he was correct because these organizations they felt like because these ladies are wife to this dude, we can give him the data, and it brought a lot of issues to the organization. They had to pay a very hefty fine. So verification process is one of the key aspects when it comes to rectification and also access of the data. Then there's the right to erasure or the right to be forgotten. You have to ensure if a data subject asks for their information, it is deleted promptly. And I'll also mention some of the tools, as I said earlier, that our organization might use. Then there's limited expectations. So organizations sometimes may refuse to erase data if it is necessary for legal or public interest reasons. And I'll also be showing you, because one thing you need to understand is these rights are not absolute. They are limited to some point, and I'll try to touch on some of the limitation for each kind of a lawful basis. And then the notification of erasure, once this is successful, the organization must inform the parties that the process has been successful and ensure there's a proper documentation in something what we call DSR or data subject log form. Then we have right to restrict processing. Individuals or persons can request that organization limits how they use their data based on the lawful basis that this data was collected for. And something also you need to note that is very critical when it comes to these lawful basis. As an organization, you cannot use data for another purpose for which lawful basis is not compatible with the lawful basis to which you initially collected that data for. What does that mean? Let's say, for example, I collected data through consent, and then this data was mainly to send marketing messages and all that. I cannot use this data maybe to subscribe these guys for an insurance cover or something, because that was not, maybe I might proclaim it like an organization legitimate interest that they feel it's a good fit for these guys to be in a pension scheme or an insurance cover. But this lawful basis, the second lawful basis, the legitimate interest is not compatible with the initial lawful basis. So that is very wrong and is punishable by the law. Then there's the verification of the request, as I explained earlier. Then there's the implementation of the restriction. Then there's the right to data portability, and I think my colleague has explained this one pretty well. There's where persons they request their copy of their personal data in any format, maybe structured, unstructured, or any machine readable format like CSVs and all that, and that data be transferred directly or indirectly or in other means to another organization. So that needs to be facilitated. But when you realize, when it comes to data portability, it is limited to personal data provided by the person, and does not extend to derived data or inferred data, or maybe data that was generated through triangulations. So that this right doesn't extend to such extents. So it only goes to an extent to where the data subject provided that data. If you give us like your identification number, that's what we have, whatever the organization it's supposed or ought to port that data to. Okay. Then this is what I was trying to talk about when it comes to different lawful bases and the rights that the data subjects might have. And when you go through these lawful bases keenly, you realize consent is one of the tricky lawful bases to deal with. And I mean, from my own perspective, I usually advise most of the organizations to stay away from consent as much as they could, because yes, with consent you can do you can erase portability, but when it comes to objection, with consent you cannot object as a data subject, but you can only withdraw consent. What does that mean? So I mean, this implies that once consent has been given, the person cannot later like claim they did not agree to the activity or the procedure. So it tries to emphasize that consent is like a proactive agreement, right? So, and then we have contract. For contract, you can object. You cannot object contract, but you can have the rest of the rights executed. For legal obligation, you cannot, as a data subject, you cannot. You do not have a right to erasure, portability, or objection. You only have predominantly right to access. Yeah. For vital interest, you do not have most of the cases. There is no right like portability or objections. As comes to public task, which is a bit aligned to, to vital interest, kind of. You cannot erasure, portability, and the rest. When it comes to legitimate interest, you have all the rights, but when it comes to portability, it's a bit tricky most of the cases, because look at it in this way. Let's say, for example, you're an employee of organization A, and we go to information, and then we usually we send your information to a particular custodian for your for the organization to manage like your pension scheme. Your employer send this information for their legitimate interest to facilitate um your pension scheme or your pension payments, to ensure that they contribute. So you cannot port data that they submitted to their pension scheme or to their custodian to you, because but they can port the data that you gave to them, and also you can have the rest of the rights. So that's how it stands when it comes to the legitimate interest. So when responding to data subject access rights, there are key things to look into. Three key things: that's the verification, timelines, and also the documentation. So once an organization receives a data subject access request, they need or they ought to verify the identity of the person making the request. To ensure that the data is not shared to the wrong persons, or the data does not land in the wrong hands, because if it does, now it causes more problems or more up. And also when it comes to timelines, so most of the times you'll find it the request must be responded within a period of a month. unless the request is a bit complex and there should be good communication between the organization and this data subject who is trying to request that data. And then after that, that right has been executed, it needs to be documented. So generally, as a requirement for the organizations or for data controllers, one of the key things that they ought to do is to have a record of processing activities, where most of the guys, they try to call it dropper. So what dropper does is like to ensure, to give a visibility of the data that has been collected within the organization, like for the purpose of collection, lawful basis, security measures that are in place, data subject rights that abide to that particular data, who they are sharing that data to, and the rest, and all of that information. But when we drill down to data subject rights, there are key documents that organizations they have to keep. One of them is the data subject access rights policy. Organization, they need to outline a policy, as much as like organization may have like IT policies, employment policies, and the rest. They need to have data subject access policies that outline everything, timelines, communication channels, and also and everything in the scope of data subject rights. And also they need to have a data subject access rights log form. This is where now they do the documentation part of it, which is one of the key things that the organization they need to do to ensure they keep a log of the guys or the persons who have requested the data. Right? Then they need to have a data subject access rights request form to ensure if someone they need to request their data, they know the process, they know the right channels of how they are going to request their information. Then there's a response form. So they need to be a standard way in which organization they communicate how they're going to give out that data and everything outlined in that form. So in the conclusion and some of the key takeaways, you realize when it comes to the data subject access rights and the whole scope, is trying to empower persons or individuals or on their rights, and I mean to ensure that they have control of their personal information, because you do not want to imagine maybe you ticked a box somewhere and you opted into a particular marketing thing, and then one day you wake up and then you're driving to work and then you find your face somewhere in the billboard trying to advertise some 2 to 3 beers. I mean, you do not want that to happen. So it tries to empower like persons to ensure they're on top of things when it comes to their data. And also to ensure like organizations comply and they do not misuse data anyhow, and to ensure like they are responsible and they take utmost care, caution when they are trying to deal with data, mostly personal information or PII data. Then promoting transparency to ensure between organizations and also data subjects, there is a kind of transparency, and to ensure each of the persons or each of the parties, they understand how the data is moving from one point to the other. And also there's the aspect of the ongoing commitment to ensure there's respect and also upholding data subject rights in an ongoing responsibility for the organizations. So yeah, so I hope I've touched a couple of things that I felt like I mean would add a bit of value. Yeah. So back to you.
Hello, Mr. Alan.
Yes, yes.
Are you done? Sorry.
Yes, I'm done. I'm done.
Okay, thank you very much for such an insightful and enlightening presentation. I'm sure the mentees have gotten a lot. Sorry, I got butted out by the network. All right, we'll go on to take our next mentor on call. I think we have Mrs. Abishola Oshi on call. So we'll take Mrs. Abishola if she's ready. Good evening, Mrs. Abishola.
Good evening. Good evening, everyone. Apologies, I was trying to, I didn't know that I was muted. Good evening, everyone. I don't, given that the two speakers have really extensively delved into this particular topic. I think I'll just look at take a more practical approach. And I want to say a big thank you to them for doing, giving a very good analysis of data subject rights. I think there are two cases this year that have been very significant in relation to data subject rights, and I think it was Oluchi that mentioned the case of Zenith Bank. Yeah, that's one important case, but I think the case that would be the landmark cases, not landmark cases, but I would just say cases that have really, really raised eyebrows for people to start taking things like data protection seriously, is the FC, Federal Consumer Protection and the Meta case, and of course the Fidelity Bank case. And whether you like it or not, those two cases involve data breaches. And a lot of times when you hear about data breaches, a lot of times they are because data subject rights have been violated in one way or the other. And I believe it was Oluchi. I hope I got her name correctly. But she said something about, yeah, it was Oluchi. Oluchi, thank you very much for the very detailed presentation. I believe what she said was something about, it's your right, as a data subject right, all these things that, data controllers or be processors are doing, to it's your right. They are violating your rights, and I think that is very, important. I mean, how can you as a lawyer, being very practical now, because, I know a lot of people are lawyers and some of them are, may not be lawyers, but at least, how can you practicalize all this that you've learned today? What is the key takeaway from, all this? I think one of the issues that, we have in Nigeria is that people don't even know their rights. To start with, the data subject rights. If you ask anybody, okay, what are the rights, for data, your right as a data subject? A lot of people will say, I don't know. I just know that, I have, my data and things like that. So I just want to say that, there are different, all the rights that they have listed, that is the right to be informed, right to access, right to rectification, right to erasure, that's the right to be forgotten, the right to restrict processing, data portability, right to object, right to automated decision making, rights to lodge a complaint, right to withdraw consent, erasure and deletion. I mean, there's so much, there's a lot of rights, but the important thing is even knowing, and I think Oluchi mentioned about breaches. I think it was the Fidelity Bank case. I think one of the issues was that they didn't even respond after the breach had occurred, and that was a problem. So one of the reasons why you're in this class is just because it's a practical class, and it's something that tomorrow, if you're sitting down somewhere and you're faced with this kind of situation, what would you do? And I think that's the most, that's one of the key takeaways. So of course, if you're talking about data subject rights, you're also talking about data breaches. You're also looking, interestingly, you're also looking in retrospect at data breaches. And it's just like how you have human rights, and, everybody's always talking about human rights and the section of the Constitution that talks about human rights. Yes, fine, but they don't really, you don't really hear about it until when these rights have been breached. And that is the same thing for data subject rights. So a lot still has to be done, just for people to even know their rights. The average Nigerian has his data, his rights, breached, in regarding privacy. Some people don't even know. Some people, they use their data to do a lot of things. So for example, someone is, I think it was, Oluchi mentioned a case about some loan apps. I believe that time it was a company called Soko Loan or something like that. Yes. They were always calling people. Some people, they would go and, they would just, paste people's pictures and different things. Those are the things. There's still a lot of work to be done in this area, but I don't want to delve in too much into what has already been said, and I don't want to overflog the issue because I know we have limited time and we still need to review the presentations. But I'll just say that it's very important that these rights are very are acknowledged by people that actually own those rights. And if you're working in a company, you're a data protection officer, or you're in the legal department that oversees data protection, you have to be very careful and be sure that your your privacy policies in the company, your data protection policies in the company, really looks at how they protect data subject rights. It will be very bad if your company, there's a breach in your company and even your data protection policy, has a problem. And that's, why it's always important for, companies to undergo the audits, the annual audits that is recommended. Yes, I know that it kind of sometimes looks like, it's just a broken record, like, okay, let's just do this audit. But it sometimes is a way to just review and look at yourself and see, that's yourself as an organization, and see, whether this, whether you are helping to protect these rights or not. But I think I'll stop here. Thank you very much.
Thank you very much, Mrs. Abishola. Thank you so much for your practical perspective surrounding non-compliance with data subject rights. Our other mentors are unavoidably absent. Mr. Ridwan Batmas had to leave. So in the absence of our mentors, the next mentors, I think we're ready to take group presentations. Are the mentees ready for their presentations? Please turn on, before we take the presentations anyway, would just take some time to take a picture. So turn on your videos. Mentees, you can now turn on your videos so we can have a picture time. Please turn on your videos so we can have we can take a picture, a group picture. Okay. All right. Okay. Thank you very much. Thank you very much. You can now turn off your videos as you so desire. So we're going to go on to take the presentations from the mentees. Group 1 is what group is ready to take their presentation?
Group 1 is ready. Good evening.
Okay, group 1 is ready. All right, you have 5 minutes. Sorry, you have 7 minutes for your presentation. Ensure to keep the time and make your presentation precise and engaging. Precise, brief, and engaging. You may go ahead. Thank you.
Thank you. Good evening. My name is Joy Izewu, and I'll be presenting for Group 1. So our topic is data subject rights. Okay. For our table of contents, we have an introduction, the comparative analysis of data subject rights across jurisdictions, the impact of emerging technologies on data subject rights, legal implications and challenges of implementing data subject rights, the role of data authorities in enforcing data subject rights, case laws, and a conclusion. So first of all, who is a data subject? So a data subject is anyone that has offered their details to a data controller or a data processor. It could be their names, identity number, anything relating to their physique, culture, or social life. So Data subject rights are rights that have been created by the law to protect individuals and citizens of a country. So data controllers and data processors are supposed to abide by these rights that were made to protect a data subject. Looking at data subject rights across jurisdiction, we looked at the NDPA, the GDPR, and the CPRA. And some of these rights that cut across jurisdictions are the right to be informed, the right to access personal information, right to be forgotten, the right to restrict processing, right to rectification, the right to object, right to data portability. So the right to rectification concerns correction of um, the data subject's details. So every data subject has a right to correct their details. They also have a right to request to be forgotten or for their data details to be deleted or erased with limitations. So I understand that the right to be forgotten and for their data details to be deleted or erased have certain limitation attached to it. Also, the data subject also has rights to restrict processing. So they can either restrict or they can restricting processing means limiting processing. So the data subject has the right to request for the data controller to limit how they process their data. The data subject also has the right to withdraw consent where this consent has been given. Lastly, the data subject has the right to lodge a complaint with the authorities. In Nigeria, that authority is the NDPC. Moving on, the challenges of implementing data subject rights. We listed two challenges. One is that some organizations lack a framework or a system to secure or protect the rights of data subjects. Also, there's the second one we listed is that technologies as AI chatbots can breach data subject right, especially when they have large data. When they collect large data from data subjects, they may violate the privacy of these data subjects when they go through it because there is no human intervention. Next, we go to the role of data protection authorities. In Nigeria, the Data Protection Authority is the NDPC, overseen by the NDPB. So this body is a regulatory body from the government that ensures that data subject rights are protected by data processors and data controllers. So their powers include the power to investigate, the power to correct, power to advise and authorize. So an example of the NDPC carrying out these roles, we can see that in the recent Fidelity Bank case where they were fined, and also the Meta case. There was also the UBA case where a a customer of the bank had a dollar account opened for them without his consent, and I think he reported to he petitioned UBA to the board, and he had justice delivered. Okay. Yeah, we have two questions from this class. Number one is, what are the penalties for non-compliance with data subject in Nigeria? Secondly, how does Nigeria handle the protection of data subject rights in the context of international data flows? So in conclusion, the rise of data subject rights is motivated by several factors, some of which includes increased awareness of data collection by organizations, which could potentially lead to misuse of personal data and identity theft. And amidst these challenges and ethical considerations posed, maintaining a balance between innovation and privacy protection is crucial. Thank you very much. Could be heard. Thank you very much.
All right, Joy. We can hear you. Thank you so much.
Thank you very much, Joy.
Mr. Nathaniel. Please continue, Mr. Nathaniel.
Thank you very much. So we're proceeding to the next presentation by the second group. Please proceed with your presentation now.
Good evening, everyone. I'm trying to share the screen. Okay. Good evening. Sorry, can you see the screen now?
Yes, Precious, we can see your screen. Proceed. You may proceed.
Okay, so the topic, our group presentation today is on data subject rights in Nigeria. That's what we're talking about today. And the table of content is, we have the introduction, the legal framework, compliance, the challenges of data subject rights in Nigeria, cultural and socio-economic factors that influence data subject rights, case studies on data subject rights, and the prospects for strengthening data subject rights in Nigeria. So basically, the advance of technology has significantly transformed the different aspects of our human life. And also, it has brought about evolving trend in our technological advancement. And because of that, we have a whole lot of unconventional cyber attack in um in our technology and all. So basically, what is data subject rights in Nigeria? Data subject rights are rights that data subject are rights whereby the data subjects have over their personal data and how information is being processed in Nigeria. And the NDPA, which is the Nigerian Data Protection Act, is one of the compliances in one of the compliances acts for protecting data protection in Nigeria. And despite the NDPA and NDPA and their provisions, we still have a whole lot of challenges in the data subject right in Nigeria. Also, some of the cultural and economic factors which has influenced data rights in Nigeria, we have the income and poverty, and we also have the economic constraints. Under the income and poverty, it tends to influence the data subject right awareness in Nigeria, and it's a big deal because data subjects are usually struggle financially, and because of that, they can't be able to assert their rights and prioritize other needs as they want to. Also, the economic constraint is that many Nigeria tend to prioritize their economic needs over their data rights. And Section 37 of the 1999 Constitution talks about privacy, and most Nigerians are not aware of their rights. They are not fully aware of that right, and they tend to neglect it, which it brings about a whole lot of privacy concern to us. Also, we have the access to information. There are limited information in order to explain what the data right and protection is all about. Public awareness is not, there's not enough public awareness, and also there are lack of understanding to all of this. So this has brought about the Nigerian Data Protection Commission. They've recognized it, and thereby they are beginning to bring public awareness and education in order to bridge this gap. Now, the case study here is, we have different case studies on the data subject rights, the violations and the remedy in Nigeria. In one of the case here, there was a violation in 2019, whereby a popular identity app was investigated, and according to according to the detail of the article in Article 11 of Truecaller privacy policy, it allows the data app to give user information to third party. Also, in one of the case study, the app was asking for more information than necessary, and asking for more information than necessary. So this was more like a violation of their right according to Article 2.3, subsection 2D of the NDPR Act. Also, in another case of emerging market telecommunication service, and Barrister Godfrey Neye, in 2018, a legal practitioner who sued the operator of Etisalat mobile line for exposing his phone number to persons and company, and that was a violation of his fundamental right under Section 37 of the 1999 Constitution as amended. He was equally awarded a damage by the Federal High Court on appeal, and the appeal court also upheld the decision. So these cases here actually outline the violations and the remedies that are being made up. Now, the future trends and prospects for strengthening the data subject rights in Nigeria. So one of the prospects in strengthening data subject in Nigeria is, one, providing training to employees who will be responsible for handling data subjects. So employees need to be trained in order to be able to handle data subjects in Nigeria and ensure that the data subject right under the NDPA and NDPR are being upheld. And secondly, establishment of a verification process should also be done too. So a process will have to be developed in order to identify who the data subject is, and also for his data not to be disclosed wrongfully. And also maintain documentation. Documentation is a very important aspect of protecting the data subject right in Nigeria. So we have they need to be compliant with the NDPA so as to maintain these various documentation, packaging, and also to deliver the data. So a data subject wants to exercise his right to a data portability by packaging and delivery of his data in a machine readable format, which also, if organizations are also requesting for this data, it will help protect their privacy. So in conclusion, the NDPA and the NDPR and other legislative laws should provide a comprehensive framework for protecting the personal data of various data subjects in Nigeria. In case of a breach, if there's a breach in their rights as a data subject, the remedy that will be given to them, and ensure compliance to the laws on the privacy and data protection of data subjects. Now, the questions that we have here are, number one, are there any limitations? Are there limitations? What's not showing? Sorry, I don't know. It's not showing fully well, but we have a group questions there.
Okay, you can type your questions on the chat box. Okay.
Okay, that would be perfect. I'll put it on the chat.
Yeah, type your questions on the chat box. Thank you very much, Precious, for your presentation and for the practical flair you added to your presentation by citing cases. All right. That brings us to the end of our mentee group presentation. We'll open questions. So mentees, if you have questions, raising your hand or typing your questions on the chat box. So at this juncture, I'll call on our mentors to take the questions that we have. I'll read out a few questions we have on the chat box here, so our mentors can address post, what are the penalties for none? What are the penalties for? Question 2, how does Nigeria handle the protection of data subject rights in the context of international data flows? How does Nigeria handle the protection of data subject rights in the context of international data flows? So I'll be calling our mentors at this point in the order of their presentations. I think I'll start with Ms. Kodichi. Ms. Kodichi, please could you address these questions? Thank you very much. Do we still have Ms. Kodichi on call? Okay. I do not think we still have Ms. Kodichi on call. Okay, in that circumstance, I'll call on Mr. Alan Goma to please take these questions.
Okay, yeah, sure. And I think when it comes to the to the question of the fines, I think it's or the penalties, I think it's pretty much straightforward when it comes to the in the act. And when I was trying to go through the act, and also think Kodichi has also gone through it well and also covered when it comes to the fines. And it states clearly that the higher or the maximum amount shall be, greater of 10,000 naira or 2% of its annual gross revenue. But now you see these amounts are determined based on the on several factors, things such as like the nature, or the gravity of the case. Let's say, for example, um like a microfinance company try to take information of a data subject, and then um they use this information maybe to apply for an extra loan. You see, this one, the organization did it for monetary gains. So the gravity of this case would be a bit heavier compared to just someone trying to send maybe a marketing message, or maybe using for other purposes. So what I'm trying to say is these fines are greatly determined um, by the gravity of the case, and also when it comes to to the purpose of processing. If 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 you used data subject rights for a legal obligation, for a lawful basis that is not compatible with the initial lawful basis that you used to collect that data for, you see that's punishable by the law, and also which reads back or returns to the gravity of the matter, and also in terms of like a duration of the infringement. But generally, you find out the fines would range between the values or the numbers that are indicated in the act. That is between 10,000 naira 2% of its annual gross revenue, or the standard maximum amount, which is like 2 million naira. Yeah. Does that answer the question? Hello, let me know if I'm audible enough. Hello, can someone
We
hear
can
me?
hear you, sir.
Yes, we can hear you.
Okay, yeah. So I hope my response has tried to answer the question fair enough. Some of these fines you'll find out, they would range they will be in that particular range, but now based on the gravity when the complaint has been uh presented to the regulator. Okay. So should I take the next one, or I was to take the first one only? Nathaniel, I think you can guide me.
Hello, hi, Alan. Thank you so much. And please, we really have to give it up for Alan. Alan is, I mean, I heard that he was from Kenya and he was answering a lot of questions, like he was responding, and he's in Nigeria. So thank you very much for that, Alan. Thank you.
You're welcome, welcome, welcome.
Yes. Just on the non-compliance question, just to add to what you said, so I don't, in my own opinion, and I have not seen that there is a specific fine for non-compliance with data subject rights. But you remember that when we're talking about data subject rights, we said that, look, why is there even a data breach in the first place if it's not that these data subject rights have been violated in the first place? So what the Act generally talks about is on data breaches and what exactly will apply for data breaches. So for example, data protection for data controllers dealing with more than 10,000 subjects, 2% of the annual gross revenue. I think the Fidelity Bank issue was based on some annual gross revenue calculation, also for data controllers dealing with less, I think is less than 10,000, I think is 1%. So I haven't seen, maybe I may be wrong, but I haven't seen in the Act that there's a specific thing for non-compliance with data subject right. What I know is that when there's a breach, data subject right violation always leads to a breach, and when that breach arises, which the Act extensively covers for, then these provisions on fines and penalties will apply. Thank you.
Yeah, I mean, and I think also to add something on the same matter is I mean, you tend to realize these regulators, when it comes to data protection regulators, they are one of the best or one of the easiest regulators to deal with, because you realize they do not like rush to give you like a penalty for a data breach or for a failure to comply with the data subject rights, but they try to guide you through, and maybe if you're difficult enough, maybe they can proceed to give you an enforcement notice, which will guide you on how, I mean, and guide you on how like to have some of the things implemented. Let's say, for example, like it's in case of like a ransom attack and all that, before they give you a penalty. Maybe if now you become difficult enough not to follow through, then it's when they will go to an extent of like giving you a penalty. Yeah.
Yes, thank you very much, Alan. Thank you very much for adding that. That's very important. Please, let's really give it up for Alan. I love the fact that, I mean, he's an international data protection professional, and he's really speaking like he's in our own climb now. So I really appreciate, his expertise on this. Thank you very much, Alan.
Thank you.
Yes. Is Nathaniel on the call? If he's not on the call, I think we can just move to the second question, just to save time.
All right. Sorry. It's like Nathaniel is no longer on the call, but then I will continue with the questions. The second question here is I think the second question here is okay, which courts has jurisdiction to enforce data subject rights? Ms. Abisola, I think this is within the Nigerian jurisdiction. So please, I would like you to help answer that question. In Nigeria, which courts have the right to enforce data subject rights? Which courts? Ms. Abisola, are you still with us?
Hi, sorry. Hello. My apologies. I'm back. Yes. So, this is a very tricky question. Because the NDPC or the NDPA doesn't specifically say a particular court would handle this. But just from, where we see some of these cases coming from, we see them from the High Court, we see them from the Federal High Court. So it's safe to say that, those two courts have jurisdiction. I know I believe for the Meta one, it was the Federal High Court. I'm not sure about that, but those two courts, the High Court of a state and the Federal High Court, should have jurisdiction over it. And a lot of times, cases that have to do with things like, violation of human rights or which data protection stems from anyway, has to do with it. And sometimes some of these cases have to do with companies also. So within those two courts, the High Court of the State and the Federal High Courts. Thank you very much.
Yeah, and I think I can also add, maybe a view of how it happens here in Kenya. Maybe I don't know whether it might be similar to how it happens there. So here, because the complaints, they come from the regulator, who is here we call them the Office of the Data Protection Commissioner. Even if you rush to go to the court, they will send you back to the Office of the Data Protection Commissioner, because it's a regulated space. They need to ensure if and also to ensure they act within the jurisdiction of the act. So predominantly, even in the case of the fines, they would give you a fine, and if you're not satisfied with the fine, then now when you can proceed to the High Court, and seek justice, to the courts after they have looked into the matter. So I don't know whether it happens the same in Nigeria. I'm not sure.
Okay, thank you very much, Alan. Actually, the NDPC just came to light not too long ago. So a lot of times, so it's just, it was formerly cases on data protection and breaches were formerly under the purview of NIDA. And, NIDA has a lot of other things that they do. I know they do a lot of technology development and transfer and things like that. So basically, they weren't, I think the NDPC just came about, was it like 2 years ago? It was first of all the NDPB and NDPC. So I think it came about 2 or 3 years ago. But now we are seeing that people are reporting, to the NDPC. There's that growing awareness. But still the courts will always, if it's something that it's really, really serious, the regulators will always give a fine to whatever organization that is not is breaching that right. So a lot of times it really truly depends on a lot of things. Thank you.
Yeah. Hello, can anyone hear me?
Yes, we can hear you.
Yes. Okay. Sorry, I had to switch device. Sorry about that. So the third question here is how does Nigeria? Okay. It says, how does Nigeria handle the protection of data subject rights? That rights in the context of international data flows. Yes, ma'am. Miss Abisola, over to you again. Right.
Okay, thank you.
Yes,
after this question, please, I will need to request as I need to leave, but I will try and answer this question as best as I can. I know that for international, data flows, it's always a very interesting topic. Even in the exams, it's always a very interesting topic. But basically, the Nigeria Data Protection Act, it permits international data transfers. However, I think I'll just rephrase it like this. So basically, when I'm talking about data subject rights and international data flows, there are two things. What are you talking about in international data flows or international data transfers? They're talking about the reciprocity of what the other country that the data is being transferred to has. So for example, you're looking at things like adequacy, the contracts, consent, legal basis, and things like that. So when these rights are being transferred, the important thing, even having all those things that I just mentioned at the background, it is important to note that there's still the data subject still has the right, to access and the right to rectification, and and whatever it is that whatever rights it is. So basically, and I'm just trying to explain this in the best possible way so that it doesn't confuse anyone. I think it has more to do with data controllers and processors as opposed to the data subject right themselves, because as a data subject right, as a data subject, sorry, I may not be the one that is transferring my own personal data. It's the data controllers and the processors that are pretty much doing that. But the important thing is them safeguarding, having appropriate safeguards, which I mentioned earlier, standard contractual clauses, obviously, binding corporate rules, consent and things like that. So those are the things that need to be taken into consideration, and just ensuring that, okay, that country that thing is being sent to, I hope that they have these things. And, there's also the issue of whitelist or no whitelist, but I don't want to get too technical, or in some things. But what I just wanted to say was that, yes, the NDPA, protects, the data subject rights. And the thing about it is that when you're talking about data protection, data subject rights, it doesn't sometimes expressly, focus on that in the act, but you can infer from it what it's trying to say. I hope I've not confused anyone. Okay, let me just leave it here, but I'm still on call.
Yeah, all right, man. Thank you so much for helping us with that question. So far, we've had a few questions that our mentors have helped us answer. So please, I would just like to ask if there are other live questions that the mentees would like to ask. Please, you can indicate by the raise of hand. I think Mr. Allen is still on the call, and Ms. Abisola is present, but I'm sure she said she will be leaving soon. But then Mr. Allen,
I'm still around. Don't worry. When I'm leaving, I'll let you know.
Oh, all right. So Ms. Abisola is still around. So please, do we have more questions? Okay, Chioma, please, you can go ahead and ask your question.
Good evening. Thank you so much to the mentors for the really enlightening class. I want to direct my question to Mr. Allen. Thank you very much. But during your presentation, there was this table you had for the data subject rights, like I think processing, portability and content, and the data subject rights and the legal basis. I didn't really understand it. So I would like if you can go over it that table again, please.
Yeah, sure, 100%.
Thank you.
Okay, I assume this is the table that you're talking about, right?
Yes, that's the table I'm talking about, yes.
Yes. So before I explain to this one, I need to take you probably to this first slide over here. You see, for example, like there are different rights when it comes to the data subjects, right? So there's the right to access, right to rectification, right to restrict processing, right to erasure, right to object and all that. So different, you see, for example, when you're collecting data from a data subject, you ought to have a lawful basis as to why you're collecting data. Let's say, for example, to give an example that I had given prior, for an employee in company A, right? So this employee might give their ID and their bank account details. So the reason as to why they gave this information, maybe it's for their personal profile, but the employer might share this information with the insurance company, maybe to facilitate for their medical staff. So you see, in this case, there are two lawful bases. One, they collected the data for their contractual obligation, but they shared this data with an insurance company for the companies or for the data controllers' legitimate interest to facilitate the conduct, right? So, as a data subject, based on the lawful basis that was used to collect your data, it also ensures that you have different rights, and every right, and as I had mentioned earlier, these rights are not absolute, right? So there are some limitations. Like, for example, if this data was used to file your returns or your returns at the end of the year, you cannot say I need to erase that data, right? You cannot say I want to port that data. Also, you cannot object the processing of that data or that particular activity. So when it comes to legal obligation, you are restricted in that case, but you can still access your data. You have the right to access your data, right? Let's go back to consent. If we collected your data for marketing purposes, you have the right to erasure, you have the right to portability, you have the right to withdraw consent, but you cannot object consent, right? And I had explained clearly, it implies that once consent had been given, the person cannot later try to claim that they did not agree to the activity or the procedure, right? Because consent most of the times is like a proactive agreement, and until it has been withdrawn, right? I don't know. Does that make it a bit clear?
Yes, yes, yes.
All right. Thank you so much, Mr.
Thank you
Allen,
very
and
much.
thank you to Chioma, right, for asking that question. Do we still have more questions? We're in the stage where we'll start rounding up the session so that we can call it a night. But then, do we still have any other person with any question? Okay, I can see Mr. Nathaniel is back. But then, do we still have questions from anyone? Okay, okay. In the absence of any questions, I want to say a big thank you to Mr. Allen and Mrs. Abisola for their time and their efforts into today's session, their talk that they gave. Also, big thanks to Ms. Kodichi and also to Mr. Ridwan Badmos in absentia, and also to Mr. Solomon Okidara in absentia. But with that, I think we're safe to say this class has been, our mentors have done due justice to the subject matter. At least they've given us through their slides and through their experience, giving us not just theoretical aspects to it, but they've also raised practical concerns and also pointed out to case studies where these rights were violated, abused, and some of the penalties that have come as a result, the penalties and the awards that have come as a result of breaches within the data subject rights. So thank you once again to all the mentees that have been on this call from start to the very end, and to the presenters who presented on behalf of your group. Good night, everyone, and enjoy the rest of your evening.